Hi, folks. Get myself situated here. I hope you are having a good day. It's the Monday after Mother's Day. I hope that if you are a mother of any kind, that you had a wonderful Mother's Day and were celebrated and felt loved. It's such an important time. My kids, let's see, Madison and I went and saw The Devil Wears Prada 2, and I loved it. I am very much a movie lover where the underdog kind of digs in, figures it out, and overcomes. And this is definitely a movie. I akin it to Legally Blonde, or I don't know. There's just so many great movies. Doctor Strange, that's one of my favorite movies for that. But we did really enjoy The Devil Wears Prada 2 yesterday. And then we went to dinner, and that was amazing at Aloha Beer Company. So that was fun. And we sat out on the back porch, and it was great time. Let's see. Oh, also new, this is my cute hair that Jess Azursky did at Harbor Hair. She does a great job. She did some little foils. It's coming together, but I got it cut, got several inches cut off. So it's feeling great. Just did a little shower and let it air dry today. But then I also got my new glasses, and I decided to go with Pair Eyewear, I think is what it's called. But look at all of these fun. Look, I can just switch them out. This is not an ad. I don't get paid to do any of this shit. But look at this. They're so cute. I'm really excited for this one. For the holidays, like New Year's, it's like little lights all around. So cute. Anyway, that's my new glasses that came in. So fun. I like that you can just have the glasses with your prescription and then get all the different toppers that you want, and they're super inexpensive, and not have to have 1,000 pairs of glasses. That's fun. All right. Well, I am going to get us into it because I have to take my son to jiu-jitsu. But what we're going to talk about today is the newish Adams Homes lawsuit. And so I'm going to talk about it in a couple phases. First thing we're going to talk about is us finding out how I found out about it and my letter to the board and the office. And then I'm going to talk about the disclosure statement that was sent to NRRAR. I'm assuming that's some kind of national realtor, something. And we'll talk through that, and I'll read what was disclosed by the board and the office for realtors. I have not seen that published anywhere else, but I may have missed it. There's been a lot going on with the candidates and all of the things coming up about the old offices and what we're going to do there. So I may have just missed it. But then we're going to talk about the complaint itself, and I'm going to read it through just like I did the last lawsuit. I'm just going to read it through top to bottom. I understand that there are two sides to every story, and I also appreciate that a complaint or a new lawsuit filed is basically allegations and shade, right? Like we feel like we have been grieved in some way, and we want someone else, a third party, after not being able to adjudicate it ourselves amongst ourselves, we need somebody else to weigh in on it. And that's what our court system is for. And this new, thank you so much, National Association of Realtors. So I can always count on you guys to help me out. So let's talk about it. Okay. I know that that's a hot topic. So I found out after the board meeting that was end of April, I think it was the 22nd or the 23rd. I just happened to see on Facebook somebody post, what did Don Moore say about a lawsuit? It sounded new. It was just like what was it that Don said about the new lawsuit in the board meeting? I've heard different descriptions about what was actually said in the board meeting. And since the board meeting was not live cast, there was equipment failure. We don't know. Okay. If you weren't there, you don't know. And everybody that was there seems to have a different opinion about how much detail was given about said interaction or comment made. So I reached out to the board. Let me share my screen. I do, just like last time, have my handy dandy thing. I'll be reading from this because I can see it better, but this is my letter. So I wrote a letter to the board saying, "Dear members of the board, I'm writing to request clarification regarding the board's communication and disclosure practices related to litigation involved in Fairfield Harbour Property Owners Association. And this is important to me because we have a property for sale right now and it's actively under contract. And as a seller, I know in North Carolina, I am required to disclose any litigation that involves a homeowners or property owners association, especially one that the house is within the boundaries of. So it's important to me. That's why this is such a hot topic for me, because I feel like it was filed, and we'll see the docket here in a minute, but it was filed March 23rd. We're not finding out till a month later, like April 23rd at that board meeting, and we still don't have anything publicly disclosed. So that's a month, that's 30 days. And whenever you're dealing in time frames like publish your house on MLS or what have you, you get a contract, and then there's a certain finite amount of time for due diligence where those disclosures and all of that stuff have to happen. And I want to do what's right by the sellers or the buyers that are buying our property. And so it's really important to me that they don't feel like I pulled the wool over their eyes and didn't tell them something. I would hate to have anybody join our community and feel like the wool was pulled over their eyes in any way. And I know I can't disclose what I don't know about, and I get that. But at the same time, 30 days for a lawsuit, and there are a lot of houses on the market in Fairfield Harbor for sale. That's a long time to go by when you will see that our attorney, who we paid to support us, actually responded within 4 days, I believe it was, of being able to respond. So we'll see in here, the board is telling me we didn't find out about this till right before the board meeting in April, but yet our attorney responded back at the end of March. And so there's a disconnect there, and we've got to be able to know about these things more time. Granted, we don't want to be sued, right? Like, we don't want the lawsuits out there, but they are out there, and we just need timely disclosure. So that's the reason why this is such a hot topic for me specifically. Specifically, speaking of, I am seeking information about the lawsuits filed by Adams Homes on March 23rd, 2026. I am currently under contract to sell a property in Fairfield Harbor. In accordance with North Carolina disclosure requirements, I disclose the ongoing litigation involving Dan Ritter et al. And Fairfield Harbour POA at the time of entering into a contract. I was not aware of the Adams lawsuit, despite it having been filed prior to the execution of my contract with the buyers, right? So it's just, I want to do things the right way. And this is why I feel so just impassioned by this topic. I became aware of the Adams Homes matter on or about April 23rd, 2026, following a brief reference of a comment made during this week's board meeting and subsequent independent research. As a result, I am now required to update my disclosure documentation with my buyers who are nearing the end of their due diligence period. To date, I have not identified a formal community-wide communication from the board regarding this lawsuit. Additionally, access to the reference board meeting was not available to members unable to attend in person, and the meeting minutes will not be published for several weeks after the board approves in next month's meeting. At that point, will be more than 60 days since the formal notice was provided. Given these circumstances, I'd like clarification on the following. Does the POA provide any formal disclosures to buyers or sellers as part of the property transfer or closing process? Like, maybe whenever we close, someone in the office gives something to the buyer's agents to say, here are our DORs, here are our bylaws, here, by the way, are the disclosures regarding active ongoing lawsuits or litigation. So does the board or the office have any say in that? What is the board's standard process and timeline for notifying property owners of material legal matters, including newly filed litigation? Does the board intend to issue a formal communication to all property owners regarding the Adams Homes lawsuit? Timely and consistent communication of material information is important for property owners who are engaged in real estate transactions and are required to comply with legal disclosure obligations. Delays or gaps in communication may create challenges in ensuring that disclosures are complete and accurate. Personally, I want to be a good neighbor. I want to ensure that buyers have all of the information they need to make an informed decision before buying property in Fairfield Harbor. I want them to be set up for success when they move in. I talked with my agent at 4 a.m. So we're back in Hawaii. So this was 4 a.m. my time, which would have been 10 a.m. Eastern time. I am on the phone with my agent, making sure that they know about this new lawsuit and that we make a good faith disclosure as timely as possible after conducting my own research, because I've heard nothing from the board in more than 30 days since the litigation was filed. There are numerous lots for sale in Fairfield Harbor. How do other sellers or buyers become aware of the suit without a formal communication strategy from the board? I appreciate your attention to these questions and request a response at your earliest convenience. Respectfully, Emily Bartlett, and then I give the 2 addresses. All right. As you can imagine, I got a couple of different responses. Jennifer responded first, which I do appreciate. Emily, we were notified after the suit was filed as well. As soon as we were aware, we were provided a disclosure for realtors to utilize on the disclosure page of any listings. I reached back out to my agent same day and said, hey, I understand we sent a disclosure to realtors to utilize for properties in Fairfield Harbor. How do you see that? Do you see that? Does someone at the National Realtors Association make you aware that this is out there? I just don't know how it works. I can also send this to you or your realtor. In today's Friday update, so this was on April 24th, there will be a link to the lawsuit as well as a brief synopsis of the claims made by Adams Homes. So I said, thanks for this response, Jennifer. I'm not sure how the NRRAR process works. Is that automatically added to any property for sale in our area, or would each individual realtor be responsible for updating that disclosure? How does the realtor know that NRRAR received something, I guess is my question. I've attached Justin, which is our real estate agent, and he's reached out to our buyer's agent to disclose. But if you can forward us what was sent, we can ensure all of our I's are dotted and our T's are crossed. That's my biggest concern, is that there is an issue down the road, whether that be procedural or with any stress that may come from POA litigation, that I could have mitigated earlier in the selling process, right, in this transaction. Dawn responded while I'm responding to Jennifer. Ms. Bartlett, thank you for your thoughtful email and bringing your concerns to the board's attention. We appreciate your diligence in seeking full and timely disclosure during your real estate transaction. Regarding the Adams Homes lawsuit filed March 23, 2026, the board became aware of this matter only a few days prior to the April 22nd meeting. The litigation was publicly announced shortly thereafter during that meeting. Unfortunately, we experienced technical difficulties with the video equipment and prevented that meeting from being broadcast. We recognize that not all members are able to attend meetings in person and understand the importance of timely and accessible communication. To address this, we have included a link to the civil summons in the weekly community update so members can review the available information directly. In response to your specific questions, at this time, the POA does not issue formal disclosure packets related to litigation as part of the property transfer or closing process. Responsibility for such disclosures generally remains with the seller in accordance with North Carolina law. And again, that puts me at risk, right? So that's where I want to make sure that I'm hedging any risks that I have as the seller in the state of North Carolina. And then including information about the Adams Homes litigation in this week's update is intended to provide a broader notification to the community. The board will continue to evaluate whether additional communication is appropriate as the matter develops. We understand your concerns regarding timing, particularly given the potential impact on active real estate transactions. Your feedback is important and will be taken into consideration as we review and refine our communications practices. You may also access the civil summons at this link below. Okay. If you have any further questions or would like to discuss this matter in more detail, please do not hesitate to reach out. That's funny. Yeah, Neil is holding communications meetings. That's interesting. Then Jennifer sends me the disclosure same day. Please be advised. So this is the disclosure that was sent to NRRAR. that is available for addition to any of the real estate transactions in Fairfield Harbor right now. Please be advised that Adams Homes AEC LLC, quote unquote Adams, has initiated litigation in Craven County Superior Court against Fairfield Harbor Property Owners Association, Inc., the association. In case number 26 CV 000-761-240, in its complaint, Adams asserts that the Property Control Committee, that's what PCC stands for, has overstepped the authority granted in the Master Declaration and CCRs for the community in its current processes and fees charged. There's no allegation in the lawsuit that would involve claims against individual property owner association property owners or result in a lien against common areas or individual lots. A full copy of the pleading in the Superior Court is provided at this link. If realtors or buyers have any questions regarding this matter, they may contact the association's office for assistance. So again, I don't know how real estate agents or buyers are made aware that these disclosures are given to NRRAR. Maybe there's like a flag or an alert, an email chain that goes out when something new happens in North Carolina, county by county. I don't know, but this is what we got. This is what we added to our listing and shared with our buyer's agents. So that's the email communication back and forth. Secondly, let's see what we got here. Let's talk about the newsletter. So in the newsletter, it was really at this week's board meeting, we had trouble with the live. Okay. At the request, that was the speed policy, which I did another podcast on last week. During the meeting, President Don Moore updated the board and those present at the meeting that Adams Homes has filed a complaint against the POA. Good Lord. Brief synopsis. Adams Homes is challenging the authority of the Property Control Committee to require appropriate stormwater control measures and the $500 charge to offset the wear and tear on Fairfield Harbor roads caused by new construction. And here's the link there. And then that was it. So that is the summary that the board provided. I feel like it could have been a little more robust, like pull directly from the complaint. They give you a summary there. But we're going to go and do our own independent research, and then everyone's going to have questions and issues and interpret it differently. Again, if we just put it out there, we have less static in the line to question the intent or what was shared or what needs to be shared or how we. Okay. So that was the newsletter that was put out on the 24th. Okay. Then we have, let me go here. Okay, I'm just going to start here. Let's read the complaint, okay? And for those that are not listening to this live, I am going to do some bookmarks in the description to try to get us. Oh, okay. So thank you so much. What Jennifer quoted in the newsletter is exactly what Don Moore read out loud at the board meeting on 4/22. Again, I think that our newsletter could be a little bit more robust than just a quick one-sentence summary, but that's just me. All right, let's read this bad boy. All right. Goodness. All right, here we go. This is a jury trial is requested, if you see under the complaint. Comes now plaintiff Adams Homes AEC LLC, otherwise known as Adams or the plaintiff in this document, by and through undersigned counsel, and hereby files its complaint against Fairfield Harbor Property Owners Association, also throughout this document known as the POA or defendant, as follows. Parties, jurisdiction, and venue. Plaintiff Adams is a limited liability company organized and existing under the laws of the state of South Carolina and authorized to conduct business in North Carolina. Upon information and belief, defendant POA is a corporation organized and existing under the laws in the state of North Carolina, having its principal place of business in Craven County, North Carolina. This has personal jurisdiction. This court has personal jurisdiction over the parties and subject matter jurisdiction over the claims asserted in this action. Venue is proper in Craven County, North Carolina. Here is the factual background. And I know on Facebook, some people got like, facts are facts, right? Like I have the facts as have been detailed by Adams Holmes under factual background. I don't have the facts as it relates to Fairfield Harbour Property Owners Association because we have not yet responded. And you'll see at the end of this, I'll just quickly go through the docket things that have been updated. But Fairfield Harbour requested an extension and they have until May 27th. So like a week and a half to get a response back to the court. So we'll be on the lookout for that. Plaintiff hereby incorporates and realleges the preceding paragraphs as if fully set forth herein. The Fairfield Harbour subdivision is a planned community containing over 2,800 individual lots located in Craven County, North Carolina. The POA manages the Fairfield Harbour subdivision pursuant to the master declarations and POA's bylaws. Adams is an experienced residential home builder that constructs new homes throughout the southeastern United States. Adams purchased 100 lots in Fairfield Harbour subdivision, the first closing occurring in December of 2021, and additional closings occurring throughout 2022 and 2023, otherwise known as their total lots. So they have 100 lots in Fairfield Harbour. Since acquiring the total lots, Adams has developed and sold approximately 35 homes. So 35% of their 100 homes or 100 lots since 2021, they have been able to develop. And currently owns approximately 65 undeveloped lots, the remaining lots. Adams intends to develop and sell the remaining lots. During the course of Adams's development efforts in Fairfield Harbour subdivision, the POA has repeatedly imposed onerous, unauthorized architectural guidelines and related approval requirements on Adams, many of which are not authorized by the master declarations. These requirements have been imposed in an unreasonable and bad faith manner and have substantially interfered with Adams's ability to develop its lots. As a result of the POA's unauthorized architectural guidelines and related approval requirements, Adams has incurred a substantial amount of additional costs and experienced significant delays, which has interfered and is currently interfering with Adams' right to use, enjoyment, and development of the total lots and remaining lots. Specifically, the POA has imposed architectural guidelines and other requirements relating to site plans, grading, drainage, erosion control, and trees that are not authorized by and exceed the authority granted under the master declaration. True and accurate copies of the following POA documents are attached hereto and incorporated herein by reference. So this document is 106 pages, but Exhibit 1 is our master declarations, Exhibit 2 are our architectural guidelines, and Exhibit 3 are our POA's bylaws, which, as you know, are a lot. For example, this is the example that I referenced on the Fairfield Harbour, I think it was the Residents of Fairfield Harbour page on Facebook when we were having some discussion about this. This is specifically the example that I referenced because it's specifically the one in their factual background. The master declaration expressly provides that a filing fee of $30 shall accompany any submission of plans and further provides that no additional fee shall be required for resubmission of revised plans. Notwithstanding this express limitation, defendant has imposed and continues to collect fees in the amount of $560 per application as a condition of plan approval. Adams has paid such fees under protest in order to avoid further delay in the development of its lots. The architectural guidelines reference to an appropriate fee does not and cannot override the express limitations set forth in the master declaration. So they're saying there is a hierarchy of documents that we follow, likely the master declaration, and then the architectural guidelines and the bylaws fall underneath that. So one cannot supersede another. Okay. Defendant's adoption and enforcement of architectural guidelines and approval requirements regulating site plans, grading, drainage, erosion control, and trees constitutes an improper attempt to expand and effectively amend the master declaration through board or committee action rather than through amendment procedures required by the master declaration itself. Under North Carolina law, homeowners associations may not impose new land use restrictions or expand existing restrictions through rules, guidelines, or discretionary approval processes where such restrictions are not clearly authorized by the governing declaration. Article 4 of the Master Declaration establishes the authority of the Fairfield Harbour Property Control Committee, otherwise known as the committee, to approve certain construction in the subdivision. The committee's approval authority is limited to all plans and specifications for any structure of improvement whatsoever to be erected on or moved upon to any property, and the proposed location thereof on any property, the construction material, the roofs and the exterior color schemes, any later changes or additions after initial approval thereof, and remodeling, reconstruction, alterations, or additions thereto on any property. Emphasis added. That's the underline. On its face, the Master Declaration unambiguously restricts the committee's approval authority to structures of improvement. The committee's approval authority does not extend to site plans, grading, drainage, erosion control, or trees. Alternatively, Article 4 of the Master Declarations is ambiguous concerning the committee's authority with respect to site plans, grading, drainage, erosion control, and trees, and under North Carolina law, such ambiguity must be resolved against the expansion of private land use restrictions and in favor of the free use of property. The Master Declaration does not authorize the committee to issue architectural guidelines. Alternatively, the Master Declaration does not authorize the committee to issue architectural guidelines that create new or additional restrictions or expand the committee's review authority beyond authorities expressly provided in the Master Declaration. Even assuming the Master Declaration authorized the committee to issue architectural guidelines, the applicable architectural guidelines exceed the POA's authority under the Master Declaration by, among other things, imposing onerous requirements relating to site plans, grading, drainage, erosion control, and trees. Alternatively, the committee's requirements relating to site plans, grading, drainage, erosion control, and trees are preempted by or inconsistent with state and local law. Alternatively, the committee's requirements related to site plans, grading, drainage, erosion control, and trees have not been and are not being enforced reasonably or in good faith by the POA or the committee. Rather, the POA or the committee are enforcing the stated requirements irrationally, arbitrarily, and capriciously. I will keep my thoughts to myself. For example, the requirement that Adams must prepare and obtain approval for individual lot-specific sedimentation and erosion control plans is unnecessary, unreasonable, and inconsistent with, and sometimes violative of state and local law. For example, the North Carolina Sedimentation Pollution Control Act, Section 113A-60, provides that when a development project contains an approved erosion control plan for the entire development, a separate erosion control plan shall not be required by the local government for development of individual residential lots within that development that disturb less than 1 acre. So many of our lots are less than 1 acre. Oh my gosh, I wish you could see it, but I had the tiniest little lizard is running across my computer screen. He might get on the camera here in a second. Apologies. So what they're saying is that when a sedimentation or a development project, when our entire community has an approved erosion control plan for the entire community, not an individual one is needed for the individual lots that are less than 1 acre, which most, if not all of ours are. Okay. With respect, I'm at number 30. With respect to the total lots and remaining lots, the North Carolina Department of Environmental Quality, NCDEQ, has approved Adams Sedimentation and Erosion Control Plan for the entire development area within Fairfield Harbour subdivision. Despite NCDEQ's approval of Adams Erosion Control Plan for the total lots, the POA has continuously mandated that Adams prepare, submit, and attain approval of individual lot-specific sedimentation and erosion control plans. And I see both sides of that, right? Because we have some areas of our community that still have swampy kind of marsh set, like standing water. And then we have some parts of our community that are very dry and at higher elevations, not requiring flood policies. So our community is very diverse in the types of land use, right? But again, what they're saying is regardless of how we feel about each individual lot or different parts of Fairfield Harbor, they have a singular sedimentation and erosion control plan for the entire community. Oh my gosh, is that the lizard on me? Oh, that lizard just jumped right on me, and I am so sorry for yelling in your ear. We coexist with the lizards here inside, and I've never had one jump on me. Apologies. But anyway, we're saying that regardless of where it is in Fairfield Harbor, if we have a land or a erosion control plan for the entire community that's approved by the state of North Carolina, what Adams is saying is that we do not by lot need to diversify that plan to be lot specific. Does that make sense? Okay. That's the way I read it. Okay. On to number 32. The POA has required Adams to prepare, submit, and obtain approval of lot-specific sedimentation and erosion control plans that conflict or are inconsistent with the sedimentation and erosion control plan applicable to the total lots that was submitted to and approved by NCDEQ. Upon information and belief, the POA has mandated individual lot-specific sedimentation and erosion control plans despite state law prohibiting local governments from imposing similar requirements on individual residential lots that disturb less than 1 acre. Each individual lot within the total lots is less than 1 acre in size. So that's all of their lots are less than 1 acre. Furthermore, the committee's process for approving site plans, grading, drainage, erosion control, and trees is irrational, arbitrary, and capricious. Specifically, the process is supervised and managed by an individual who is not a licensed engineer. This individual, currently Mr. Ray Redness, whom, full disclosure, I love. Just saw him when we were back in North Carolina. You can't tell me he's doing everything in his, like, in good faith. He is following what he believes to be right and true. So I am just full disclosure here on my part. Essentially, the eyeballs the lot and dictates what he wants the site plan, grading, and drainage plan to be without reference to or consideration of any appropriate or recognized engineering guidelines. Surveys are then often obtained along with a drainage plan, which is reviewed by Mr. Redness and the committee, who sometimes requires additional revisions and changes to the plans. Accordingly, the changes mandated by Mr. Redness are based on the lay opinion of Mr. Redness and the committee and are not predicated on the sound engineering principles. The committee's approval process interferes with Adams' right to use and develop its property, unnecessarily delays lot development, and significantly increases development costs without any rational or legitimate basis. Moreover, the following components of the architectural guidelines and the committee's process for approving site plans, grading, drainage, erosion control, and trees are not based upon sound engineering principles and are applied in an arbitrary and inconsistent manner, requiring grading and grading of lots as multiple stages of construction without any defined standard, imposing inconsistent and conflicting erosion control requirements from lot to lot. I'm now on C. Requiring revisions to previously approved grading, drainage, and erosion control plans without any objective criteria or change conditions, and mandating multiple, duplicative, and costly surveys without justification or uniform standard. A recent example of the committee's unauthorized and unreasonable enforcement is reflected in the process required to obtain a building permit for 1920 Cara Drive, New Bern, North Carolina. This is Section 6, Montego, Lot 365. Contrary to the express provision of the master declaration and beyond the scope of the architectural guidelines, the committee required submission of a 14-page permit application, compliance with an 11-page land development permit checklist, issuance of a purported white ready-to-build certificate, mandatory pre-construction grading of the lot, a site inspection and approval of the committee, and only thereafter issuance of a green permit authorizing vertical construction. True and accurate copies of the following are attached hereto and incorporated herein. So we have Exhibit 4. So beyond our master declarations, the architectural guidelines, and our POA bylaws, which are Exhibits 1, 2, and 3, we are adding Exhibits 4, 5, 6, and 7. Exhibit 4 is the application for residential building permit. Exhibit 5 is the land development permit checklist. Exhibit 6 is the white ready to build certificate. And Exhibit 7 is the green permit authorization for vertical construction for this 1920 Cara Drive. The arbitrary nature of the committee's requirements is further demonstrated by its enforcement of purported stormwater and drainage standards that lack any objective basis. The architectural guidelines reference approved community stormwater management plans, purportedly available for review. However, upon information and belief, no such community-wide stormwater management plan exists. I will say it's likely we just can't find it on front steps because we don't have a good document management strategy. But I hope that it does exist for our sake. This has been confirmed by individuals involved in the original engineering of the development, as well as individuals currently responsible for stormwater oversight within the community. Despite the absence of any governing plan, the committee continues to impose shifting and unsupported drainage and grading requirements, resulting in inconsistent and unpredictable approval standards. Currently, Adams Homes is in the process of developing more than 30 lots, all of which are materially delayed and burdened by the unauthorized, onerous, and irrational committee approval process, resulting in ongoing interference with Adams' vested property rights. All conditions precedent to the bringing of this action have been performed, have occurred, and have been waived. The plaintiff has brought this action within the applicable statutes of limitation and repose. So this is claim 1, our claim for declaratory judgment. Plaintiff hereby incorporates and realleges the preceding paragraphs as if fully set forth herein. Number 45, the master declaration governs the POA's limited authority to review and approve building plans in the Fairfield Harbour subdivision. An actual and justiciable, that's a really hard word, justiciable controversy exists between Adams and defendant regarding the extent of the POA's authority to review and approve building plans in Fairfield Harbour subdivision and to impose architectural guidelines, rules, and restrictions relating to site plans, grading, drainage, erosion control, and trees. Thus, relief in the form of a declaratory judgment is proper. Plaintiff is entitled, I'm at 47, to declaratory judgment that under the master declaration, the committee's approval authority does not extend to site plans, grading, drainage, erosion control, and trees, except to the extent they involve structures. Plaintiff is further entitled to a declaratory judgment that the master declaration does not authorize the committee to issue architectural guidelines at all, or alternatively, to issue architectural guidelines that are inconsistent with the master declaration. Plaintiff is further entitled to a declaratory judgment that the committee's issuance of architectural guidelines relating to site plans, grading, drainage, erosion control, and trees is invalid and unenforceable because such guidelines are inconsistent with the master declarations and exceed the POA's authority granted by the master declaration. Plaintiff is further entitled to a declaratory judgment that the architectural guidelines and other committee requirements relating to site plans, grading, drainage, erosion control, and trees preempted by state and local law. I'm at 51. The alternative, plaintiff is entitled to a declaration that, if enforceable, the POA or the committee are enforcing the architectural guidelines and other requirements relating to site plans, grading, drainage, erosion control, and trees against Adams unreasonably or in bad faith. Claim number 2 is a breach of the master declarations. Plaintiff hereby incorporates and realleges that the preceding paragraphs as if fully set forth herein, the master declaration constitutes a binding set of covenants and obligations governing the rights of the association and lot owners within Fairfield Harbour subdivision. Again, if you have been in Fairfield Harbour 100 years, or you are new to Fairfield Harbour within the past 2 days, and you have not read our master declaration, our bylaws, we have a vote for new board members coming up. These are so important to you to understand what rights that you have as a property owner. We are the Property Owners Association. Please inform yourself. Read these documents. I am not going to read them in full today. All of these exhibits attached, we're not going through 106 pages, but please read them. If we need to read them as a group, I am happy to do individual one-offs to read through them. Okay? But please, the Master Declaration constitutes a binding set of covenants and obligations governing the right of the association and lot owners within the Fairfield Harbor subdivision. Plaintiff, as a lot owner within the Fairfield Harbor subdivision, it is entitled to the benefits of the limits, protections, and procedures established by the Master Declaration. Defendant is bound to act in accordance with the Master Declaration and may not impose additional approval requirements or substantive restrictions beyond those authorized by that declaration. By imposing and enforcing approval requirements, restrictions, and review criteria relating to site plans, grading, drainage, erosion control, and trees that are not authorized by the Master Declaration, the defendant has breached the Master Declaration and the restrictive covenant regime governing the Fairfield Harbor subdivision. Number 57, by promulgating or enforcing architectural guidelines that exceed the authority granted by the Master Declaration, defendant has further breached the rights of Adams enjoys as a property owner within Fairfield Harbor subdivision. As a direct and proximate result of the defendant's breaches, plaintiff has suffered damages including delay damages, increased carrying costs, additional survey and design expenses, administrative and resubmittal costs, increased construction costs, and impairment of its property rights. Claim number 3, ultra vires conduct. Again, we're going to incorporate and re-allege all of the preceding paragraphs as if they are reinstated in full. Number 60, the rights, duties, and authority of the POA, its board members, agents, and the committee are defined and limited by the Master Declaration, the association's bylaws, and applicable law. Under the Master Declaration and governing documents, the POA, its board members, agents, and the committee possess only those powers expressly granted by the Master Declaration and such powers as are reasonably necessary to carry out those express powers, and they may not exercise authority beyond the scope of those governing documents or applicable law. The Master Declaration establishes the standards, procedures, and limitations by which the POA, its board members, agents, and the committee may adopt, impose, enforce, or limit property rights of lot owners, including the property rights associated with lot owners by Adams within the Fairfield Harbor subdivision. And by adopting, imposing, and enforcing guidelines, standards, and review requirements concerning site plans, grading, drainage, erosion control, and trees that are not authorized by or that exceed the authority granted in the Master Declarations, the POA, its board members, agents, and the committee have acted beyond the scope of their lawful authority, including without limitation, the imposition of the unauthorized white permit and green permit approval process. I'm sorry, my glasses keep sliding because it's like 92 degrees in my house and 187% humidity. By adopting, imposing, and enforcing guideline standards and review requirements unreasonably or in bad faith, the POA, its board members, agents, and the committee have acted beyond the scope of their lawful authority. Number 65. Defendant's imposition and collection of fees in excess of $30 constitutes a direct breach of the Master Declaration. The POA's, its board members, agents, the committee's conduct alleged here and above, therefore constitutes ultra vires acts that are unenforceable against Adams. Ultra vires, if you remember from the first one, is after the fact, right? Like so. As a direct and proximate result of the POA, its board members, agents, and the committee's ultra vires conduct, Adams has suffered damages and is entitled to declaratory relief, injunctive relief, and monetary damages as allowed by law. So while some members of the office and the board will tell you this doesn't really impact us as home buyers or sellers, other than the fact that by North Carolina law, we have to disclose any litigation with our property owners association. It does impact us, especially if the courts and or a jury trial vote, like award this suit to Adams, and we are responsible for providing injunctive monetary damages back to them. That comes out of our dues. So it is important for all of us to understand what is happening here, even though we may not actively be building a home. This still impacts all of us. Okay. And if you have been following any of the threads related to the most recent accountant, what's his, a treasurer's note by Lee Fawcett, it impacts us all. If you know, you know. If you don't know, call me. My number's pretty much everywhere in Fairfield Harbor, or direct message me on Facebook Messenger, which I am not great at, so it may take me a little bit, or text me, but please reach out to somebody, because this does impact all of us if this is awarded to Adams. Let's see. Claim number 4. Again, we're incorporating and realleging all preceding paragraphs as if we restated the whole thing herein. Number 69, the defendant's adoption and enforcement of architectural guidelines and approval requirements concerning site plans, grading, drainage, erosion control, and trees exceed the authority granted under the Master Declaration. Defendant's conduct constitutes an ongoing interference with Adams' property rights and its ability to develop and use its lots within the Fairfield Harbor subdivision. Adams has no adequate remedy at law for defendant's continuing interference with its property rights. Unless enjoined by this court, defendant will continue enforcing unauthorized approval requirements that delay construction, increase development costs, and interfere with Adams' lawful use of its property. Adams is therefore entitled to preliminary injunctive relief prohibiting defendants from enforcing architectural guidelines and approval requirements relating to the site plans, grading, drainage, erosion control, and trees that exceed the authority granted under the Master Declaration until final judgment is entered in this action. This is the last of the claims, claim 4. Let me just finish before I say what I want to say. Wherefore, plaintiff respectfully prays that this court, 1, enter a declaratory judgment finding that under the Master Declaration, the committee's approval authority does not extend to site plans, grading, drainage, erosion control, and trees, except to the extent such matters involve structures of improvement under a declaratory judgment finding that the Master Declaration does not authorize the committee to issue architectural guidelines at all, or alternatively to issue architectural guidelines that are inconsistent with the Master Declaration. 3, enter a declaratory judgment finding that the applicable architectural guidelines with respect to site plans, grading, drainage, erosion control, and trees are invalid and unenforceable because they are inconsistent with the Master Declaration. Enter a declaratory judgment that the architectural guidelines and other committee requirements relating to site plans, grading, drainage, erosion control, and trees are preempted by state and local law. Number 5, alternatively, enter a declaratory judgment that the committee's architectural guidelines and other requirements relating to site plans, grading, drainage, erosion control, and trees are not being enforced reasonably or in good faith by the POA or the committee. Number 6, award plaintiff compensatory damages for the injuries caused by the defendant's breaches of the Master Declarations and ultra-vires conduct, including delayed damages, increased carrying costs, additional engineering and survey costs, administrative expensive and increased construction costs in an amount to be proven at trial. 7, issue a preliminary injunction prohibiting the defendant, its officers, directors, agents, the committee, and any persons acting in concert with them from enforcing architectural guidelines or approval requirements relating to site plans, grading, drainage, erosion control, and trees that exceed the authority granted under the Master Declarations until final judgment in this action. Number 8, for a permanent injunction prohibiting defendant, its officers, directors, agents, and the committee, and persons acting in concert with them enforcing architectural guidelines or approval requirements relating to site plans, grading, drainage, erosion control, and trees that exceed the authority granted under the Master Declaration until final judgment in this action. Number 9, award plaintiffs the cost of this action, including reasonable attorney's fees. 10, for a trial by jury as to all issues raised herein. And 11, order plaintiff have and recover such other and further relief from defendant as this court may deem just and proper. This 23rd day of March, 2026. Again, I am not going to read through all of these exhibits today, but they are here. You will see Exhibit 1. These are our master declarations. And if we just do a quick, oh, I don't know, can we do like let's just do a quick search on oh no, I want to do it here. In our master declarations, this is where we talk about, so on page 25 of 106, there shall be submitted to the committee 2 complete sets of the final plans and specifications for any and all proposed improvements, the erection or alteration of which is desired, and no structures or improvements of any kind shall be erected, altered, placed, or maintained upon any property unless and until the final plans, elevations, specifications, therefore, have received written approval as provided in this article. Such plans shall include plot plans showing the location of the property of the building, wall, fence, or other structure proposed to be constructed, altered, or placed or maintained, together with the proposed construction material, color schemes for roofs and exteriors thereof, and proposed landscape planting. A fee of $30 shall accompany the submission of such plans to defray committee expenses. No additional fees shall be required for resubmission of plans revised in accordance with committee recommendations. Then they have 30 days to approve, blah, blah, blah. This is page 25 of the master declarations. The next time, there's no other fees in there at all in the master declarations. We're on down into the architectural guidelines in Exhibit 2. This is a capital. These are our bylaws, as you can see from the top. Okay, so here on Exhibit 4, page 71 of 106, we are talking about the Property Control Committee message to property owners. This application is only for, this is their actual application for building permit. Okay. Is for a new house and must be approved before a POA residential building permit can be issued. Compliance with rules and regulations during and after construction is your responsibility. The declaration of restrictions state that once construction of improvements is started on any lot, the improvements must be substantially complete in accordance with the plans and specifications as approved within 6 months from commencement. The committee defines and substantially complete home and home site as one that meets the following criteria. Exterior shall be completed, all construction debris shall be removed, and the lot shall have its final grade with erosion control measures in place so that soil does not migrate off-site. All ditch, swell work, and installation of the driveway culvert shall be complete. Information supplied by you enables the Property Control Committee to verify compliance with the Declaration of Restrictions and Architectural Guidelines. Additionally, some rules and agreements, in particular importance to the Property Control Committee, included in this application. Careful attention to details should expedite the review and approval process and minimize potential misunderstandings. No work of any kind, including tree removal, backfilling, or grading, is to be started until Sections 6 and 7 of this application have been approved by the Stormwater Management Committee. Once approved, the initial land development may be completed and the SMC notified. That's the Stormwater Management Committee, SMC. If substantial compliance with the approved plans, the SMC will issue a ready-to-build certificate without which the PCC will not approve the issuing of a POA building permit. The house is not to be occupied by you, your tenants, or others until the Property Control Committee is satisfied that all construction work has been completed in conformity with this application as approved and a POA certificate of occupancy has been issued. Failure to comply may result in referral to the adjudicatory panel for resolution. The building permit and certificate of occupancy issued by Craven County are not to be considered substitutes for those issued by the Fairfield Harbour Property Owners Association. The application is to be signed by both you and your contractor. 2 copies are to be submitted together with 2 copies of the existing survey plan, 2 copies of the site development plan, 2 copies of the house plans, and 2 copies of the contractor's certificate of insurance. Insurance coverage is to include general liability, automobile liability, workers' compensation, certificate of insurance, to show date of issuance, name of insured, and the Fairfield Harbor Property Owners Association as an additional insured to the Fairfield Harbor Property Control Committee, together with an application and development fee in the amount of $560. In addition, any outstanding POA dues and or lot charges must be paid in full before a POA building permit will be issued. By initialing the checklist items in sections 6 and 7, be sure to review the plans for compliance if an item does not apply to your property. For example, items 9 through 12 on the site development plan checklist, do not initial it, simply enter NA. Okay, so this is our blank form. I'm not going to read through all of these, but I am just looking for dollar signs here where we talk about monies. So this is now we've got, this is the actual application for 1920 Cara Drive. And it says at the bottom of this, Fairfield Harbor Property Control Committee, together with an application fee of $30 and a development fee in the amount of $500. Okay. We have signed. And now we're back up to the master declarations. I don't like the fact that in our DORs it says 30 and 560, and then in our previous it says 30 and 500 on this actual application that they filled out. We have to be consistent, right? It just has to all, if we change it one place and it exists other places, we have to do our due diligence to search everywhere that these numbers exist. This has happened to us so many times. And again, it's because we do not have a good document management process. And so it's very hard. But anyway, the other thing I want to just point out here, if I may, is if we go back, where did I see it? Nope, this is the actual docket. Where we talk in here, oh, this is hold on. The newsletter is what I'm looking for. Brief synopsis. Adams Homes is challenging the authority of the Property Control Committee to require appropriate stormwater control measures and the $500 charge to offset the wear and tear on Fairfield Harbor roads caused by new construction. The $500 charge, according to the documents that we just read through, are not necessarily for roads. Nowhere in that complaint do we talk about roads. There are so many other things, erosion control, drainage, like all these things, but roads are not mentioned. And again, I just want people to be forthcoming with all of the information. Again, any kind of complaint like this is allegations in shade, and we should take them as such. And there's another side to be heard, but let's talk about the other side. So we talked about the actual complaint. We read through all of that. Notice of appearance. Hope Carmichael and Kelton Eckbald hereby make an appearance on this matter on behalf of Fairfield Harbor Property Association. Here's our complete contact information. This was on the 27th day of March. So it was filed on the 23rd day of March. Hope Carmichael and Kelton Eckbald enter and appear. It says, making an appearance in this matter 3 days later on the 27th. And then we have the affidavit of service. And this is where they provide, on March 26, copies of the summons and complaint were sent via Federal Express overnight delivery service to the defendant. Copies of the summons and complaint were received by the defendant on the 27th as evidence in Exhibit A. This is the FedEx document that says that they received them. And then, but yet our board and the office weren't made aware until right before the board meeting, April 22nd. I don't know how that happens. And again, it's all about timely communication, especially for those of us with skin in the game on property transactions, right? Because we are required to disclose these things. And again, it's not that we aren't building a new home, and so this doesn't really matter to us. If this is awarded to Adams Homes and all of the declaratory judgments are awarded to them, including all of the fees that they see as having lost their sunk costs to date, right? Plus attorney's fees and things like that, it comes out of the dues that we pay towards our legal fees. And so it does impact all of us. So I'm going to leave it at that. We read through my email communication and why this is so important to me specifically. We read through the National Realtors Disclosure Statement that our office sent to the North Carolina Realtors Association. And then we read through the complaint itself, some of the supplemental information, including some of the disconnects between the $30 and the $500, or is it $560? Is it to go towards stormwater drainage usage or roads, as it's stated in the newsletter? It really, there are dots not connecting. So I'm excited to see, again, on the April 8th, I'm saying we, because Fairfield Harbour Property Owners Association is all of us, requested an extension for good cause. And so we have until May 27th to file a response. So I have a tickler on my calendar to look on May 27th, 28th, 29th. It should be fairly quickly once we submit something that is available in the docket. And then we'll do another one of these just to update on what Fairfield Harbor's factual background is for this. So I hope this was helpful. I hope that it was informative. And please, again, if you are new to Fairfield Harbour or you've lived here for 100 years and need to refresh yourself on what our master declarations are, what our architectural guidelines are, what the bylaws are, please do that. Now is the time ahead of the upcoming elections. Okay. So if that would be something that's valuable to you or helpful to you, if we just take a few hours and read through them, please let me know. I would love to do that. Okay. With that, I hope you have a wonderful week and we will talk to you soon. Thanks, everybody. Bye.